Physically, where were Hillary Clinton's servers?
The operational server was in the basement of her home in New York. The reason I'm answering it that way is sometimes after they were decommissioned, they were moved to other facilities, storage facilities, but the live device was always in the basement.
Was that an authorized or unauthorized location?
It was an unauthorized location for the transmitting of classified information.
Is it reasonable or unreasonable to expect Hillary Clinton would receive and send classified information?
As Secretary of State, reasonable that the Secretary of State would encounter classified information in the course of the Secretary's work.
Via email?
Sure, depending upon the nature of the system. To communicate classified information, it would have to be a classified rated email system.
But you did find more than 100 emails that were classified that had gone through that server, correct?
Right, through an unclassified server, correct.
Yes. So Hillary Clinton did come to possess documents and materials containing classified information via email on these unsecured servers, correct?
That is correct.
Did Hillary Clinton lie?
To the FBI? We have no basis to conclude she lied to the FBI.
Did she lie to the public?
That's a question I'm not qualified to answer. I can speak about what she said to the FBI.
Did Hillary Clinton lie under oath?
Not to the FBI, not in a case we're working.
Did you review the documents where Congressman Jim Jordan asked her specifically, and she said, quote, "There was nothing marked classified on my emails, either sent or received," end quote?
I don't remember reviewing that particular testimony. I'm aware of that being said, though.
Did the FBI investigate her statements under oath on this topic?
Not to my knowledge. I don't think there's been a referral from Congress.
Do you need a referral from Congress to investigate her statements under oath?
Sure do.
You'll have one. You'll have one in the next few hours. Did Hillary Clinton break the law?
In connection with her use of the email server, my judgment is that she did not.
Did you just not able to prosecute it, or did Hillary Clinton break the law?
Well, I don't want to give an overly lawyerly answer. The question I always look at is there evidence that would establish beyond a reasonable doubt that somebody engaged in conduct that violated a criminal statute? And my judgment here is there is not.
The FBI does background checks. If Hillary Clinton applied for the job at the FBI, would the FBI give Hillary Clinton a security clearance?
I don't want to answer a hypothetical. The FBI has a robust process in which we adjudicate the suitability of people for employment in the Bureau.
Given the fact pattern you laid out less than 48 hours ago, would a person who had dealt with classified information like that, would that person be granted a security clearance at the FBI?
It would be a very important consideration in a suitability determination.
You're kind of making my point, Director. The point being, because I injected the word Hillary Clinton, you gave me a different answer. But if I came up to you and said that this person was extremely careless with classified information, the exposure to hostile actors, and used, despite warnings, created unnecessary burdens and exposure. If they said that they had one device and you found out that they had multiple devices, if there had been email chains with somebody like Jake Sullivan asking for classification changes, you're telling me that the FBI would grant a security clearance to that person?
I hope I'm giving a consistent answer. I'm not saying what the answer would be. I'm saying that would be an important consideration in a suitability determination for anybody.
And it's just, personally, I just think that sounds like a bit of a political answer, because I can't imagine that the FBI would grant a security clearance to somebody with that fact pattern. Do you agree or disagree with that?
Just say what I said before. Again, it's very hard to answer in the hypothetical. I'll repeat it. It would be a very important consideration in a suitability determination.
Did Hillary Clinton do anything wrong?
And what do you mean by wrong?
I think it's self-evident.
Well, I'm a lawyer, I'm an investigator, and I hope a normal human being.
Do you really believe there should be no consequence for Hillary Clinton and how she dealt with this?
Well, I didn't say, I hope folks remember what I said on Tuesday. I didn't say there's no consequence for someone who violates the rules regarding the handling of classified information. There are often very severe consequences in the FBI involving their employment, involving their pay, involving their clearances. That's what I said on Tuesday, and I hope folks walk away understanding that just because someone's not prosecuted for mishandling classified information, that doesn't mean if you work in the FBI, there aren't consequences for it.
So if Hillary Clinton, or if anybody, had worked at the FBI under this fact pattern, what would you do to that person?
There would be a security review and an adjudication of their suitability, and a range of discipline could be imposed from termination to reprimand, and in between suspensions, loss of clearance. So you could be walked out, or you could, depending on the nature of the facts, you could be reprimanded. But there is a robust process to handle that.
I've gone past my time. I yield back. Now recognize the ranking member. 5 minutes, and then members will ask questions. Ms. Del Greco, the GAO report asserts that the FBI failed, even though it's directed by law, to put out the privacy impact assessment. Why did the FBI not fulfill the law, the requirement of the law, and why did you not update the privacy impact assessment? You have to put the DOJ. So what do you mean defer?
The privacy impact assessment was submitted to the department. I will defer to them for a response.
I'm sorry, we're having a hearing to ask you the questions, and the DOJ would put you up there. You seem like a very nice person, but you're supposed to be the one to answer that question. What do you mean defer?
As I've stated,
right? Director Howard, you want to comment on this?
Yes, that's correct. It was submitted years after both systems were being used for real-world use.
So here's the problem. You're required by law to put out a privacy statement, and you didn't. And now we're supposed to trust you with hundreds of millions of people's faces in a system that you couldn't protect, even with the 702 issue. You know, we're talking about Mr. Flynn and how he was unmasked and all that, and there can be political gyrations, but set the name aside and Donald Trump and all that. But even in that most stringent circumstance where they're looking at information, somebody decided to take off that veil and release that out to the public. And we're supposed to, and the Office of Personnel Management had tens of millions of federal workers who had information, and some of it included fingerprints and other types of things, and that was stolen and let out, and those people are having to suffer the consequences the rest of their lives. Why should we trust you?
the privacy was part of the entire process in the development phases of the interstate photo system.
I know, but okay. The point is, as the GAO has rightfully, I think, pointed out, the FBI was required by law to comply with the law. You are part of the Department of Justice, and you failed to do so. I hope you can see how this is a problem.
A privacy impact assessment was initiated in 2008 on a pilot project for a proof of concept. Throughout the whole process, our privacy attorney was being advised of the changes that were being made in the development.
Yeah, well, we don't believe you. And the second part of that is you're supposed to make that public. And the failure here is years after it was supposed to be made public, you didn't do it. You were using it in a real-world circumstance. You were actually using it and didn't issue the statement. Let me move on. You said a couple of times, Ms. Del Greco, in your testimony that this was and I quote, an investigative lead, that everybody should relax. It's just being used for an investigative lead, correct?
That is correct.
So why not collect everybody's fingerprints? That would be an investigative lead, right? Wouldn't that be easier if you had everybody's fingerprints? Why not collect everybody's fingerprints?
We use fingerprint technology as a positive identification, and we still do today.
But why not collect them all in advance? I mean, that would be easier, right? If you had a database, you collect them all in advance. Then when you go and you pull off somebody's fingerprints, you got a database, right? Why not do that?
Fingerprints are collected with a criminal mugshot. for an arrested purpose, for a law enforcement purpose.
But you see the difference, right? Somebody's actually arrested, then they take their fingerprints. Somebody who is actually convicted, then you collect, then you have your fingerprints. But why not get them all in advance? What if we had all 330 million Americans' fingerprints in advance? That would be easier, wouldn't it? It would be easier, right? That's a question.
We collect fingerprints with a criminal law enforcement purpose only.
Right, right. Why not collect everybody's DNA? How about when everybody's born in the United States, we take a little vial, a sample of blood? Why don't we do that? And then we'd have everybody's DNA. And then when there's a crime, then we could go back and say, oh, well, let's collect that DNA, and now we have 330 million Americans. That would be easier, wouldn't it?
I'm not at liberty to speak about the DNA collection.
This is different. See, this is how DNA is a valuable investigative tool. Fingerprints are a valuable investigative lead and tool. But what scares me is the FBI and the Department of Justice proactively trying to collect everybody's face. And then having a system with a network of cameras where if you go out in public, that too can be collected. And then used in the wrong hands, nefarious hands, somebody in government misusing it, it does scare me. Are you aware of any other country that does this? Anybody on this panel? Is there any other country that's doing this? Let me ask you one other thing, and I'm going past my time here. Do you have plans to match this database up with anything that's posted on social media? So in other words, if you go up on Instagram, Facebook, Snapchat, and whatever the next new technology is, are you collecting that information that is out there on social media?
No, we are not. The only information the FBI has and have collected in our database are criminal mugshot photos. We do not have any other photos in our repository. That's not true. You're not collecting driver's licenses? We do not have driver's license photos in our repository at the FBI.
Does anybody care to weigh in on this? Mr. Bedoya?
Sure, Mr. Chairman. I think this is a technicality. Who owns and operates a database matters a lot less than who uses it and how it's used. The FBI has access to now 18 states' driver's license photos. It either can run those searches or request them. We're talking more than a third of all Americans. So the FBI does have access to these photos, has searched them tens of thousands of times, and apparently by GAO's testimony, never audited those searches for misuse.
Would you disagree with that, Ms. Del Greco?
We have access to the data. We do not maintain the data in our repository. And the access we have is pursuant to the provision in the Driver's Protection Act within the state accordance with federal law.
Does anybody else care to weigh in on this topic? Ms. Lynch?
Thank you, Mr. Chairman. I would also add that the FBI has civil photos in its repository, so it's not just relying on driver's license databases, but it also has access to civil photos in its own NGI IPS database. These photos may in the future come from background checks that people submit to as trying to get employment or as a licensing requirement, but the database is not limited to just mugshot photos.
Would the chairman yield?
Sure.
To me, the only way that an interview takes place with the two central witnesses and the subject of the investigation is if the decision has already been made that all three people in that room are not going to be charged.
Okay, can I respond?
Yes, please.
I know in our political life sometimes people casually accuse each other of being dishonest, but if colleagues of ours believe I am lying about when I made this decision, please urge them to contact me privately so we can have a conversation about this. All I can do is tell you again, the decision was made after that because I didn't know what was going to happen in that interview. She maybe lied during the interview in a way we could prove. Let me finish. I would also urge you to tell me what tools we have as prosecutors and investigators to kick out of an interview someone that the subject says is their lawyer.
That's not my point. The interview never should have taken place. if you were going to allow the central witnesses that you needed to prove the case to sit there and listen to the testimony that the subject was going to give. It never happens. It never happened to you, and it's never happened to me or any other prosecutor that I've met. And I know you've defended the people that were involved in this as being great, but if it's never happened, I wonder why this is a case of first precedent with respect to that practice that you and I have never seen in our careers.
You and I don't control the universe of what's happened. I suspect it's very unusual. A key fact, though, that maybe is leading to some confusion here is we had already concluded we didn't have a prosecutable case against Heather Samuelson or Cheryl Mills at that point. If they were targets of our investigation, maybe we would have canceled the interview. But frankly, our focus was on the subject. The subject at that point was Hillary Clinton.
All right, let me move on. According to the FBI's own documents, Paul Gambetta was, in his first interview on February the 18th, told FBI agents that he had no knowledge about the preservation order for the Clinton emails, correct?
I don't know the dates of that, but I'm sure it's in the 302.
Okay, but then 2.5 months later, on May the 3rd, his second interview, he made a 180-degree turn. And he admitted that, in fact, he was aware of the preservation order, and he was aware of the fact that that meant that he shouldn't disturb the Clinton emails, correct?
Yep.
Okay, well then I need your help again here, because when I was at the Department of Justice, your reward for lying to federal agents was an 18 U.S.C. 1001 charge or potential obstruction of justice charge. It wasn't immunity.
Depends on where you're trying to go with the investigation. It's a low-level guy, and you're trying to move up in the chain, you might think about it differently.
Well, he lied to an FBI agent. You don't think that's important?
Oh, it's very important. Happens all the time. Unfortunately, it's very, very important. Sometimes you prosecute that person and end their cooperation. Sometimes you try and sign them up.
But if they lie to an FBI agent after they're given immunity, they violated the terms of their immunity agreement.
Oh, sure, after the agreement.
And so that's my point. He shouldn't have immunity anymore.
Oh, I'm sorry, I may have misunderstood you. He lied to us before he came clean under the immunity agreement and admitted that he had deleted the emails.
No, not according to the FBI's documents. He had the immunity agreement in December of 2015. These interviews took place in February and March and May of this year, 2016.
Gambetta?
Gambetta.
Okay, then I'm confused and misremembering, but I don't think that's right.
Okay. Everything. Do you think that any laws were broken by Hillary Clinton or her lawyers?
Do I think that any laws were broken? Yeah. I don't think there's evidence to establish that.
Okay. Well, I think you're making my point when you say there's no evidence to establish that. Maybe not in the way she handled classified information, but with respect to obstruction of justice. And you've got a pen here. I just want to make sure the record's clear about the evidence that you didn't have, that you can't use to prove. So this comes from the FBI's own report. It says that the FBI didn't have the Clintons' personal Apple server used for Hillary Clinton work emails. That was never located, so the FBI could never examine it. An Apple MacBook laptop and thumb drive that contained Hillary Clinton's email archives was lost, so the FBI never examined that. 2 BlackBerry devices, provided the FBI didn't have SIM cards or SD data cards. 13 Hillary Clinton personal mobile devices were lost, discarded, or destroyed with a hammer, so the FBI clearly didn't examine those. Various server backups were deleted over time, so the FBI didn't examine that. After the State Department and my colleague Mr. Gowdy here notified Ms. Clinton that her records would be sought by the Benghazi Committee, copies of her emails on the laptops of both of her lawyers, Cheryl Mills and Harold Mills, and Heather Samuelson, were wiped clean with bleach bits, so the FBI didn't review that. After those emails were subpoenaed, Hillary Clinton's email archive was also permanently deleted from the Platte River Network with bleach bit, so the FBI didn't review that. And also after the subpoena, backups of the Platte River server were manually deleted. Now, Director, hopefully that list is substantially accurate because it comes from your own documents. My question to you is this. Any one of those in that very, very long list, to me, says obstruction of justice. Collectively, they scream obstruction of justice. And to ignore them, I think, really allows not just reasonable prosecutors, but reasonable people to believe that maybe the decision on this was made a long time ago not to prosecute Hillary Clinton.
These individuals destroyed documents pursuant or took it out of federal custody pursuant to our subpoena and our discovery. As a result, they committed crimes. My question to you is, when I was a chairman and I wanted to grant immunity to somebody, I had to go notice the Department of Justice, and you were consulted. Isn't that correct?
In a particular matter?
In any matter.
I don't know whether the FBI is consulted in that circumstance.
Okay, for the record, yes, the Department of Justice does not grant immunity without checking with federal law enforcement to see whether it'll impact any ongoing investigation. That's the reason we have a requirement to give notice. When the reverse was occurring, you were granting, handing out like candy, according to some, immunity. Did you, or to your knowledge, Department of Justice, confer with Chairman Goodlatte, Chairman Chaffetz, Chairman Smith, or any of the other chairmen who had ongoing subpoenas and investigations?
Not to my knowledge.
So isn't there a double standard that when you granted immunity to these 5 individuals, you took them out of the reach of prosecution for crimes committed related to destruction of documents or withholding or other crimes pursuant to congressional subpoenas?
I don't think anybody was given transactional immunity.
Oh, really? Now, we have not allowed to make your immunities public, but I'm going to take the privilege of making one part of it public. I read them. You gave immunity from destruction to both of those attorneys, not just turning them over, the documents over, specifically destruction. You did the same thing with these other 2 individuals, Brian and Paul Cabetta. You gave them immunity from destruction.
Director, in your opening comments, you said this was an unusual case. I would say that's the understatement of the year. Husband of the subject meets with the Attorney General 3 days before Secretary Clinton is interviewed by the FBI. 9 people get to sit in with Secretary Clinton during that interview. One of those was her Chief of Staff, Cheryl Mills, who was the subject of the investigation. 5 people get some kind of immunity. 5 people get some kind of immunity, yet no one is prosecuted. 3 of those people who get immunity take the 5th in front of Congress, and one of them doesn't even bother to show up when he's subpoenaed. He's supposed to have been at that very chair you're sitting at. And of course, the Attorney General announces that she's going to follow your recommendations, even though she doesn't know what those recommendations are, the only time she's ever done that. So of course this was unusual. We've never seen anything like this, which sort of brings me to the post. I'd like to put up the post that some have talked about, which is the post by Mr. Combetta on Reddit. And you said earlier that you don't know if you examined this during your investigation, so let's examine it now. I need to strip out a VIP's address from a bunch of archived email. Basically, they don't want the VIP's email address exposed to anyone. Now, Director, when I hear the term strip out email address, I think of somebody's trying to hide something, somebody's trying to cover up something, and it sort of raises an important question from these 2 sentences. Who's the they who wants something hid, and who's the VIP who also wants something hid? Director Comey, is it likely the VIP well, actually not just a VIP, it's a very, very important person according to Mr. Combetta. Is it likely that that person is Secretary Clinton?
Yes, sure.
Okay, and is it also likely that the they refers to her Secretary Clinton's staff and specifically Cheryl Mills?
I don't know that. Either her lawyers or some staff that had tasked him with the production.
So one other thing that's important on that, if we could put that back up, one other thing that's important is the date. The date at the top says July 24th, 2014. So whenever I see a date, I'm sure you do the same thing, I always look at what's happening about that same time frame, what may have happened directly before that, and maybe directly after that. So I went back to your reports that you guys had given to us. The first report back last month, August 18th, 2016, page 15. On page 15 it says, during the summer of 2014, State Department indicated to Cheryl Mills a request for Clinton's work-related emails would be forthcoming. State Department gives Cheryl Mills a heads up that she's got to go round up all of Secretary Clinton's email. On that same page it says the House Select Committee on Benghazi had reached an agreement with the State Department regarding production of documents on July 23rd, 2014, just the day before, which I find kind of interesting. Then from your report that we got just last week, after reviewing several documents dated in and around July 23rd, 2014, Paul Combetta had a conversation with Cheryl Mills, and after reviewing a July 24th, there's that date again, 2014 email from Brian Pagliano, Paul Combetta explained Cheryl Mills was concerned Clinton's then current email address would be disclosed publicly. So, sure looks to me like it's Secretary Clinton, as you said, but also that it's Cheryl Mills and Brian Pagliano who are urging Mr. Combetta to cover this stuff up. You agree?
From what you read, it sure sounds like they're trying to figure out a way to strip out the actual email address from what they produce.
Well, they're actually trying to strip it all out. PST filed everything. Here's the takeaway in my mind. Mills gets a heads up, Cheryl Mills gets a heads up in midsummer of 2014. July 23rd, the day before Mr. Combetta's Reddit post, the Benghazi Committee and the State Department reach an agreement on production of documents. Cheryl Mills has a conversation with Paul Combetta. He goes on Reddit then and tries to figure out how he can get rid of all this email. Even though he's not successful then, he has to do it later down the road with BleachBit. And then the clincher. The clincher. Just last week, he's going online and trying to delete these Reddit posts. He's trying to cover up.
Chair thanks the gentlewoman. Recognize the gentleman from South Carolina, Mr. Gowdy, for 5 minutes.
Well, thank you, Mr. Chairman. I want to start by acknowledging progress. I think it's important that we do so. This morning, we've had 9 straight Democrats talk to the FBI about emails without asking for immunity. That's a record. And I suspect the reason that they have not asked for immunity from Director Comey is they would say they've done nothing wrong. I find that interesting because that's exactly what Heather Samuelson and Cheryl Mills' attorneys said. In fact, they said it just a few days ago, and I'll quote it. The FBI considered my clients to be witnesses and nothing more. And then Ms. Mills and Ms. Samuelson's attorney said this. I think this is the most interesting part. The Justice Department assured us my clients did nothing wrong. Well, Mr. Chairman, if you're assuring subjects or targets or witnesses, whatever you want to call them, that they've done nothing wrong, it does beg the question, what are you seeking and receiving immunity from? I mean, if you've done nothing wrong, laptops don't go to the Bureau of Prisons, Mr. Chairman. People do. So the immunity was not for the laptop. The immunity was for Cheryl Mills. And if the Department of Justice says you've done nothing wrong, it does beg the question of why you are seeking or receiving immunity. And it could be, Mr. Chairman, for a couple of different, it could be for the classified information that was the genesis of the investigation. It could be for the destruction of federal records, which came from that initial investigation, or it could be both. Mr. Comey, I want to ask you this. Did the Bureau interview everyone who originated an email that ultimately went to Secretary Clinton that contained classified information?
I don't think so. Nearly everyone, but not everyone.
Well, you and I had a discussion the last time about intent. You and I see the statute differently. My opinion doesn't matter. Yours does. You're the head of the Bureau. But in my judgment, you read an element into the statute that does not appear on the face of the statute. And then we had a discussion about intent. So why would you not interview the originator of the email to, number one, determine whether or not that originator had a conversation with the secretary herself?
There were a handful of people who the team decided it wasn't a smart use of resources to track down. One was a civilian in Japan, as I recall, who had forwarded something that somehow got classified as it went up, and the other were a group of low-level State Department people deployed around the world who had written things that ended up being classified. Nearly everyone was interviewed, but there was a small group that the team decided it isn't worth the resources.
Well, to that extent, if you interview the overwhelming majority of the originators of the email, will you make those 302s available to Congress? Because I counted this morning 30-something 302s that we do not have.
Okay. I'll go back and check. My goal is maximum transparency, consistent with our obligations under the law. I'll check on that.
Well, and I appreciate it for this reason. Intent is awfully hard to prove. Very rarely do defendants announce ahead of time, I intend to commit this crime on this date. Go ahead and check the code section. I'm going to do it. That rarely happens. So you have to prove it by circumstantial evidence, such as whether or not the person intended to set up an email system outside the State Department, such as whether or not the person knew or should have known that his or her job involved handling classified information, whether or not the person was truthful about the use of multiple devices, whether or not the person knew that a frequent emailer to her had been hacked, and whether she took any remedial steps after being put on notice that your email or someone who's been emailing with you prolifically had been hacked. And whether or not, and I think you would agree with this, Director, false exculpatory statements are gold in a courtroom. I would rather have a false exculpatory statement than a confession. I would rather have someone lie about something and it be provable that that is a lie, such as that I neither sent nor received classified information, such as that I turned over all of my work-related emails. All of that, to me, goes to the issue of intent. So I got two more questions, then I'm going to be out of time. For those who may have to prosecute these cases in the future, what would she have had to do to warrant your recommendation of a prosecution? If all of that was not enough, because all of that's what she did, if all of that's not enough, I mean, surely you cannot be arguing that you have to have an intent to harm the United States to be subject to this prosecution. I mean, that's treason. That's not a violation of this statute.
No, I think we'd have to be able to prove beyond a reasonable doubt a general awareness of the unlawfulness of your conduct. You knew you were doing something you shouldn't do. And then, obviously, that's on the face of the statute itself. Then you need to consider, so who else has been prosecuted and in what circumstances, because it's all about prosecutorial judgment. But those two things would be the key questions. Can you prove that the person knew they were doing something they shouldn't do, a general criminal intent, general mens rea,
but the
and
way to
treated
prove,
other people similarly?
The way to prove that is whether or not someone took steps to conceal or destroy what they've done. That is the best evidence you have, that they knew it was wrong, that they lied about it.
It's very good evidence. Always want to look at what the subject said about their conduct.
Well, and there's a lot. There's a lot. If you saw her initial press conference, it all falls under the heading of false exculpatory statement. I'm out of time, Mr. Chairman, but the director did. You started off by giving us examples of things the Bureau has done. And every one of us who's worked with the FBI, that is the FBI that I know. The one that went and saved that girl in North Carolina, that is the FBI that I know. What concerns me, Director, is when you have 5 immunity agreements and no prosecution, when you are allowing witnesses who happen to be lawyers, who happen to be targets, to sit in on an interview. That is not the FBI that I used to work with. So I've been really careful to not criticize you. In fact, I said it again this morning. They wanted to know, was he gotten to? Did somebody corrupt him? No, I just disagree with you. But it's really important to me that the FBI be respected. And you got to help us understand. Because it looks to me like some things were done differently that I don't recall being done back when I used to work with them. And with that, I would yield back to the chairman.
Can I respond to that?
Yes, you may.
I hope someday when the political craze is over, you will look back again on this, because this is the FBI you know and love. This was done by pros in the right way. That's the part I have no patience for. Sorry, sir.
The chair recognizes the gentleman from Rhode Island, Mr. Cicilline, for 5 minutes.
Thank you, Mr. Chairman, and thank you, Director Comey, for your extraordinary service to our country. And please convey to the professionals at the FBI my gratitude for their exemplary service to the people of this country. And particularly, I want to acknowledge the extraordinary, prompt, and effective response to the recent bombings in New Jersey and New York. It's just another example of this extraordinary agency and your extraordinary leadership. Director Comey, many of us have expressed a concern about the growing incidence of gun violence in this country, and we expressed condolences and concern following the recent mass shootings in Burlington, Washington.
This very nice hearing room available to us while the Judiciary Committee hearing room is under renovation. So, gentleman's recognized for 5 minutes with my thanks.
Well, and I appreciate the extra 5 minutes of questioning for doing so, so thank you very much. Director, thank you for your accessibility. You have been very readily available, and we do appreciate that. This investigation started because the Inspector General found classified information in a non-secure setting, and the FBI went to a law firm and found this information. They seized at least one computer and at least one thumb drive. Did you need an immunity agreement to get those?
It was not. I don't think there was immunity. In fact, I'm certain there was no immunity agreement used in connection with that.
So, did it really take the FBI a full year to figure out that Cheryl Mills and Heather Samuelson also had computers with classified information on?
No. It took us to that point in the investigation to insist that we try to get them.
Were you getting them because they had classified information or because there was some other information you wanted?
No, we thought those were the tools, as we understood it, that have been used to sort the emails. And the investigative team very much wanted to understand, if they could, whether there was an electronic hail of how that had been done. Because the big issue was, what did they delete, what did they keep?
But why did you need an immunity agreement? Why didn't they just cooperate and hand them over? The law firm did, didn't they?
Well, yes. That's a question really I can't answer. That's between a lawyer and her client and the Justice Department lawyers. For whatever reason, her lawyer thought it was in her interest to get an active production immunity agreement with the Department of Justice.
The FBI interviewed David Kendall's partner, but did not interview David Kendall. Why didn't you interview David Kendall?
I don't remember. I don't remember that decision.
Going back to this Reddit post, this is put up on July 24th of 2014. You believe this to be associated with Mr. Gambetta, correct?
Yes, I think that's right.
This is the one that Mr. Jordan put up about the need to strip out a VIP's very VIP email address and a bunch of archived email. This is he's referring to a federal record, isn't he?
I don't know exactly which records he's referring to.
How is this not a conscious effort to alter federal records? I mean, the proximity to the date is just stunning.
I'm sorry, what's the question?
How is this not a conscious effort to alter a federal record?
Well, it depended on what the record was and exactly what he was trying to do, and whether there would be disclosure to the people they were producing it to, saying we changed this for privacy purposes. I just don't know sitting here.
These are documents that were under subpoena. These federal records were under subpoena. They were under a preservation order. Did Mr. Gambetta destroy documents?
I don't know whether that was true in July of 2014. They were under subpoena.
Did he ultimately destroy federal records, Mr. Gambetta?
Oh, I have no reason to believe he destroyed federal records.
He used bleach bit, did he not?
Yeah, the question is what was already produced before he used the bleach bit. He definitely, the reason he wanted immunity was he had done the bleach bit business after there was publicity about the demand from Congress for the records. That's a potential.
And not just publicity, there was a subpoena.
Right, that's potential.
And there was communication from Cheryl Mills that there was a preservation order, correct?
Yes.
And he did indeed use bleach bit on these records.
Sure. That's why the guy wouldn't talk to us without immunity.
And so when you got immunity, what did you learn?
We learned that no one had directed him to do that, that he had done it.
You really think that he just did this by himself?
I think his account, again, I never affirmatively believe anybody except my wife, but the question is, do I have evidence to disbelieve him? And I don't. His account is credible, that he was told to do it in 2014, screwed up and didn't do it, panicked when he realized he hadn't, and then raced back in and did it after Congress asked for the records and the New York Times wrote about them. That was his SHIT moment. And that was credible. Again, I don't believe people, but we did not have evidence to disbelieve that and establish someone told him to do that. No email, no phone call, nothing. The hope was, if he had been told to do that, that would be a great piece of evidence. If we give him immunity, maybe he'll tell us, so-and-so told me to, so-and-so asked me to, and then we're working up the chain.
But he did indeed destroy federal records, and he was told at some point to do this, correct? Who told him to do that initially? When he was supposed to do it in December, and he didn't do it. Who told him to do that?
One of Secretary Clinton's staff members, I can't remember sitting here, we know that. One of her lawyers might have been Cheryl Mills. Someone on the team said, we don't need those emails anymore, get rid of the archive file.
This is what's unbelievable about this, because there's classified information, there are federal records that were indeed destroyed. And that's just the fact pattern. Let's go back to this. Here's the other thing that I draw to your attention that is new. September 15th of this year, I issued a subpoena from the Oversight and Government Reform Committee. On these Reddit posts, 4 days later, they were destroyed or taken down. They were deleted. I would hope the FBI would take that into consideration. Again, we're trying under a properly issued subpoena to get to this information. Let's go to Heather Mills real quick. How does in the 2016 interview with Cheryl Mills, she says, quote, Mills did not learn, in the interview report, the interview summary from the FBI, Mills did not learn Clinton was using a private email server until after Clinton's tenure. Back, also, you have this interview with Mr. Pagliano, who said he approached, quote, Pagliano then approached Cheryl Mills in her office and relayed a State Department employee's concerns regarding federal records retention and the use of a private server. Pagliano remembers Mills replying that former secretaries of state had done similar things, to include Colin Powell. It goes then on to a page 10, and this is what I don't understand. The FBI writes, Clinton's immediate aides, to include Mills, Abedin, Sullivan, and a redacted name, told the FBI they were unaware of the existence of a private server until after Clinton's tenure at State, or when it became public knowledge. But if you look back at the email from Heather Mills, if you go back to 2010, this is to Justin Cooper, okay? Mills to Cooper, who does not, he works for Clinton's. He doesn't work for the State Department. FYI, HRC email coming back. Is server okay? Cooper writes back, you are funny. We're on the same server. She knew there was a server. When there was a problem with Hillary Rodham Clinton's emails, what did they do? She called the person who has no background in this, who's not a State Department employee, no security clearance, and then tells the FBI, well, I never knew about that. But there's direct evidence that contradicts this. How do you come to that conclusion and write that in the summary statement that she had no knowledge of this?
That's a question?
The
Yes.
time of the gentleman has expired, but the director will answer the question.
I don't remember exactly sitting here. Having done many investigations myself, there's always conflicting recollections of facts, some of which are central, some of which are peripheral. I don't remember sitting here about that one.